of Orange, Chatham counties, and I will be the moderator tonight. Before we get started, just a couple housekeeping items. We ask that you mute your microphone so that we don't pick up any background sound. And we will do Q&A at the end of the session, so you can put your questions in the chat, and then I will go through them with Whitney at the end. And you may have just seen we are recording this session tonight for publication probably in a few days on our website. So I'm going to also go over our disclaimer or statement of where the League stands. We are the purpose of the League is to promote political responsibility through informed and active participation in government. The League is nonpartisan in that it does not support or oppose any political party or candidate. And so tonight, we're going to continue our lecture series on the democracy. And we started this last spring when we hosted a series on the fragility of democracy, and continued this past Tuesday when we hosted the first of our two-part series on our democracy, our rights, our democracy. And we explored women's health and reproductive rights. Dr. Kreitzer covered a wealth of information on cases, policies, and laws regarding women's reproduction since the late 1800s, bringing us up to date on the most recent state laws that have been passed. Tonight is the final event of our two-part series. We will look at the role and responsibility of the Supreme Court as it pertains to reproductive rights and beyond. I would like to welcome our speaker, Dr. Whitney Manzo. Dr. Manzo holds a Ph.D. from the University of Texas at Dallas in political science and methodology. Her research agenda focuses on balances of power and issues of representation. She has served as president of the North Carolina Political Science Association, the Southern Political Science Association, and the Southern Association of Pre-Law Advisors. Her focus is American politics, and her primary expertise is in the area of public opinion, constitutional and electoral law, elections, and gender issues in politics. And so I will turn it over to Dr. Manzo.
Thank you so much for having me. I'm so excited to speak with you all again after last year when I spoke with you all. So what I'll do is I will share my screen. Okay. Can you all see my PowerPoint? Okay, awesome. So today I'm going to be talking about the Supreme Court, not only in 2022, but the ending, we'll end up in 2022 and kind of where we're going with the Supreme Court. But first, I want to talk about just the overall structure of the Supreme Court. How do cases get there? How do they make a decision on what kind of case to take? Just so we have an overall basis of how the Supreme Court works before we move into talking about the politics of the Supreme Court. So first of all, where do we get the Supreme Court from? And it's in Article 3 of the Constitution. I've copied Section 1 here, which talks about how the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. So what that means is that we have to have a Supreme Court, but all other courts in the United States are entirely made up by Congress. So they could decide tomorrow to take them all away. The only one that they cannot remove is the US Supreme Court, because the Constitution lists that one by name. Section 1 goes on to say the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. And that has traditionally been interpreted to mean lifetime appointment. And they shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. So what that means is whatever Congress has decided to pay federal judges, they cannot reduce that pay while that person is in office. Now, they can reduce the pay of future justices, but once someone has their salary set, it cannot be diminished by Congress. And the reason for that is so that Congress cannot politically retaliate against a justice by reducing their salary. You'll notice, though, that there's no mention of a Supreme Court building. So the Supreme Court building itself is controlled by Congress. They could also take that away. And in fact, for many years in the beginning of the Supreme Court, they actually held trials in the lower level of Congress. So if you ever get to travel to DC and tour the Capitol building, which has been under very strict lock and key since last year, January 6th. But if they open it up again, and if you can going to see the original Supreme Court room in the lower level of the Capitol building is really neat. But they eventually did build the Supreme Court its own building that is provided by Congress. So this is where we get the idea of a Supreme Court, and it's also where we get the idea of lifetime appointment. So the main power of the Supreme Court is judicial review. And what this is the idea that, as Marbury versus Madison says, it is emphatically the province and duty of the judicial department to say what the law is. So Marbury versus Madison is one of the most famous cases in constitutional law. And the reason why is it's because it's the case where the Supreme Court explicitly said, we have the power to tell the other branches what the Constitution says. So the case of Marbury versus Madison is a funny one because it is kind of like the Real Housewives of the Founding Fathers when I tell this story to my students, because it really originates in how much the Chief Justice, John Marshall, hated Thomas Jefferson, who was the new president. So at this time, the first kind of constitutional crisis that we came to in the United States was whenever Thomas Jefferson was elected in the election of 1800, with the idea that we were transferring power for the first time from the Federalist Party, who had been in power with George Washington and then John Adams, to the Democratic Republicans, which was a different party run by Thomas Jefferson. And so this was the first time where we were testing, like, does the Constitution actually work? Will we have a peaceful transfer of power? Well, the Federalists were very concerned about the Democratic Republicans undoing all of the work that they had done to set up the new country. So they set out to fill the courts with a bunch of Federalists with the idea that they would overturn anything the new Democratic Republican administration wanted to pass. So if one of your questions is today the Supreme Court more political than it ever has been? The answer is no. It's been political since the very beginning because of this fight between the two political parties. So as the Federalist administration of John Adams is leaving, they're signing a bunch of judicial commissions, like literally the day before they have to leave the White House. They're signing judicial commissions. And one of them is for Marbury. And he's supposed to be a new judge that's going to be put into the courts in all of these newly created positions that would stock the courts with Federalists. Well, some of the commissions are left on the desk in the White House. And the next morning, James Madison, who is going to be Thomas Jefferson's Secretary of State, comes in and does not deliver several of these commissions because he's of the Democratic Republican Party. He doesn't want to give the courts all of these Federalists. So he does not deliver several commissions, including Marbury's. And Marbury sues, saying that Madison should be forced to give him his commission. Well, it goes all the way to the Supreme Court. And John Marshall he's the new Chief Justice, and he had just been the Secretary of State who was supposed to deliver these commissions. So like literally he's signing these things and then the next day he starts his new job as Chief Justice of the Supreme Court. And so this case comes before him, and politically he wants to give the commission to Marbury because it's his party and he wants to help fill the courts with Federalists. But he knows that if he tells Thomas Jefferson, you have to give Marbury his commission, Thomas Jefferson will just ignore him. So Marshall is faced with a conundrum here over how he can get his way, but also not be flouted by Thomas Jefferson. So he ultimately issues this decision in Marbury versus Madison, which says that Marbury should get a commission if the Judiciary Act that created his position was constitutional. But he ultimately decided that the original creation of his position was unconstitutional, and therefore Thomas Jefferson didn't have to give him his commission. The reason why this is very impactful is it's the first time where the Supreme Court explicitly writes out, we get to decide what is constitutional and what isn't. And this is not uncontroversial. As we'll see in a second, Thomas Jefferson is not very impressed by this idea. But this story is funny, and I like to tell it because it shows like the politics of the Supreme Court truly do go back to the beginning and some of the original fights that our own founding fathers had about the power of the government and who gets to do what. So Marbury versus Madison establishes judicial review, and Thomas Jefferson says a few years later, this case of Marbury versus Madison is continually cited by bench and bar as if it were settled law, without any animadversion on its being merely a dissertation of the Chief Justice. So this is Thomas Jefferson writing after he's president about how Marbury versus Madison has become this case that lower courts cite, and he doesn't know why, because he's like, this is entirely made up by John Marshall. But because all of these lower cases start citing, or lower courts, excuse me, start citing it, it becomes more and more of a thing until it is now ensconced in our law. And this is the power of the Supreme Court, is judicial review. But what a lot of people don't know is that they did kind of create it for themselves. Later, Charles Evans Hughes, who was a Supreme Court justice in the early 1900s, he was actually an associate justice, and then he resigned from the Supreme Court so that he could run for president. He did not win. And then later, he is later appointed Chief Justice of the Supreme Court. So he's actually on the court in two different time periods in the early 1900s. He said, we are under a constitution, but the constitution is what judges say it is. And the judiciary is the safeguard of our liberty and our property under the Constitution. So he is admitting that judicial review involves the judges saying what the law is, which does sound kind of like the judges are getting to decide things for themselves. But he says at the same time, the judiciary is the thing that's protecting us from government going too far. So he actually views judicial review very positively, unlike Thomas Jefferson, because he views it as a responsibility. This is a good thing that we have to protect our fellow Americans. And John Roberts in 2005, he's the current Chief Justice of the Supreme Court, he famously said during his confirmation hearings that judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. So again, we hear a very positive take on what judicial review is, which is the idea that they're just making sure all of the branches are playing fairly according to our US Constitution and protecting the rights of our Americans. So now that we have the idea of judicial review, it's the power of the courts to say what is constitutional and what isn't. I want to talk a little bit about the differences in how people talk about the courts. So a lot of times whenever I hear people talk about the Supreme Court, they kind of conflate three different things that are actually distinct ideas. So one of them is judicial role, which is the attitude a judge has towards other branches of the government. One of them is judicial interpretation, which is the approach a judge takes towards decision-making. And then the third is actually their political ideology, which is the attitudes that they hold. And I'm going to talk more about each of these, but they are different. So sometimes you'll hear people talk about activist judges when really they mean liberal judges. Or you'll hear people talk about originalism when really they mean conservatism. So let me dive a little deeper into the differences between these three. Judicial role is the approach that a judge has towards the other branches of government, and whether or not they view the judiciary as an equal branch of government or a lesser branch of government. So quote unquote activist judges view the judiciary as a co-equal branch with Congress and with the executive, and they can and should overturn those two branches if it is warranted, and they should not be afraid to do so. Quote unquote restraintist judges, on the other hand, view the judiciary as the third lesser branch. So Congress should be first because that was Article 1. The executive should be second because that was Article 2. And the judiciary should be third because that was Article 3. So their idea is that the Constitution was written that way on purpose, with the idea that Congress should be first, followed by the executive, and then the judiciary is just there as the third lesser branch. And because of that, they should only overturn the other two branches if it's very necessary. So there's a judge who said that you should only overturn the executive branch or Congress if it doesn't pass the puke test, or if the idea makes you want to puke, then you can overturn them. But if it doesn't, then you shouldn't overturn them because the judiciary is the third lesser branch. So activist judges are more okay with overturning things. Restrainist judges are less okay with overturning things. This is distinct from how a judge interprets specific decisions. So originalism is the idea that a judge should stick to the original meaning or text of the Constitution, which is distinct from living constitutionalism, or the idea that interpretation of the Constitution should be updated as our society updates. And I'm going to dive a little deeper into these two ideas because you hear them talked about a lot in Supreme Court confirmation hearings, as we saw last week. So originalism, I have some quotes here from 3 Supreme Court justices talking about what it is. But the idea here is that, as Amy Coney Barrett says, it's not up to me to update the Constitution or infuse my own policy views into it. So she should just interpret the Constitution as it was written at the time the people adopted it in 1789. Antonin Scalia, the person who she replaced on the court, said that originalism is the only judicial interpretation that fits with democracy. And so you can kind of get the sense here of how an originalist and a restraintist could go together, because the idea is that in a democracy, the democratically elected positions of the president and the Congress should be the more important positions, and judges should be lesser because they're appointed. So once a nation has decided that democracy with its warts is the best system of government, the crucial question becomes which theory of textual interpretation is compatible with democracy. Originalism unquestionably is. Non-originalism, by contrast, imposes on society statutory prescriptions that were never democratically adopted. So for him, originalism is a way to protect our democracy by not allowing judges to put their own quote unquote spin on the Constitution. And Clarence Thomas has a similar idea. Words have meaning at the time they are written. When we read something that someone else has written, we give the words and phrases used by that person natural meaning in context. To not interpret laws based on their meaning when they were enacted usurps power from the people. So again, this idea that originalism is really about protecting democracy. And as with all things, there are pros and cons to this idea. Part of the pros that Amy Coney Barrett, Clarence Thomas, and Antonin Scalia talked about were that it is supposed to be value-free. The judge cannot use their own political ideology. They are only using the interpretation of the Constitution as it meant to Americans in 1789, or for the later amendments when those amendments were adopted. So for example, the 14th Amendment is adopted in 1870, then what does the 14th Amendment mean in 1870? It also promotes stability in law because, again, if you are only deciding things as the Constitution was written, then that's not going to change. The text only changes when we amend it, so that there is stability over time over how the cases are interpreted, ideally. But there are cons to this idea. The first being, what was the original meaning of the Constitution? And most importantly, to whom? Because as you saw with my story about Thomas Jefferson and John Marshall, who were founding fathers, and John Adams and George Washington, these were all people who we consider founders of the American government, and they did not agree. We get our political parties from them. So the idea that there is one universal meaning to the Constitution that all the founding fathers held is patently false, because we know that they did not all hold the same ideals. That's why they established different political parties. So it's really hard to try to determine what the original meaning of something was if there are two competing ideas from the founding fathers. Also, originalism can be hard whenever new ideas or new technological advances pop up. So for example, the Supreme Court had to deal with a case about whether or not it violates the Fourth Amendment for law enforcement to use thermal scanners outside of your home without a warrant. How does an originalist make that decision? What was a thermal scanner in 1789? The Fourth Amendment doesn't speak about this. They would have no idea the capabilities that law enforcement would have in 2005. So one of the struggles of originalism is what to do when we have advances in technology and advances in new ideas that the Constitution itself doesn't talk about. How can you then take that idea and its original meaning and apply it now if you're not using any values? So the flip side to this is living constitutionalism. And I have two Supreme Court justices, Felix Frankfurter and Stephen Breyer. And then I also have a US President, Ulysses S. Grant, talking about it. And they're all in, again, like the people who were in favor of originalism were about promoting democracy and stability. These three men are all about how it's crazy to think that a document written in 1789 should govern future generations because things change. So as Ulysses S. Grant said, it is preposterous to suppose that the people of one generation can lay down the best and only rules of government for all who are to come after them and under unforeseen contingencies. So he's getting at the exact con of originalism, which is, what do you do with new situations? And that's why he's saying you can't just use the same old document because it doesn't deal with the new situations. Felix Frankfurter, who was a Supreme Court justice in the early 1900s, said, "The words of the Constitution are so unrestricted by their intrinsic meaning, or by their history, or by tradition, or by prior decisions, that they leave the individual justice free, if indeed they do not compel him to gather meaning not from reading the Constitution, but from reading life." So for him, the words of the Constitution are already malleable. They were not meant to cover every situation that any American might encounter. It's not that long of a constitution comparatively around the world. So his idea is that you actually, as a justice, your role is to take the idea of the Constitution, maybe not exactly the text, but the idea, and apply it to what you have learned in life. And he goes on to say, I didn't include it here because I didn't want to fill up the screen, but he goes on to say that if you're not doing that, if you're trying to stick to just the words of the Constitution, then you're ignoring the life that you see around you. and that's not going to make for good law. And then Stephen Breyer, who is currently on the court but going to retire at the end of this term, said that this understanding underlying constitutional interpretation since the New Deal reflects the Constitution's demands for structural flexibility sufficient to adapt substantively laws and institutions to rapidly changing social, economic, and technological conditions. So he's arguing that in fact, since the New Deal, which in the 1930s, that all Supreme Court justices have really used a version of living constitutionalism because they had to in the face of changing social, economic, and technological conditions. As you might be able to tell already, the pros and cons of living constitutionalism are the flip of what they were for originalism. So a pro of living constitutionalism is that the Constitution can be updated and stay relevant to the current generation without having to make any amendments. We don't have to change the document itself. We can just change how we view it through the courts. And then also, living constitutionalism accommodates new ideas and phenomenon because it is able to think about what's the idea of the Fourth Amendment. Maybe it doesn't talk explicitly about thermal scanners, but I can think that the idea of the Fourth Amendment is to protect people in their homes. And if that's the general idea of the Fourth Amendment, then no, a thermal scanner would not be allowed because it is invading the home without a warrant. So you can handle these new technological advances under living constitutionalism in a way that's harder under originalism. Of course, the main con that any originalist throws at living constitutionalism is that you're just saying whatever you want to say. You want to be able to update the Constitution to fit your political ideas, and you're not actually using the document itself in the way that it's meant to be used. So there won't be stability anymore, and you are imposing your will instead of the will of the people. These ideas do get conflated with political ideology, which is the political attitudes that justices hold. Justices on the Supreme Court are just like you and I. They have political attitudes that they believe in. They're not robots. They aren't there to just, type in the Constitution and then spit out a decision. They do have to use their own thoughts and values and ideas. And political scientists have established that about 57% of the time, you can know how a judge is going to vote on a case just by knowing their political ideology. So you can see I've stolen this image from the political science article, one of the several that talks about it. And it shows that if you know the political ideology of the justice in civil liberties cases or in economics cases, the R is what you're looking at here. What that means is, for example, under Roosevelt and Truman, 47% of the time, they could guess the civil liberties outcome. For justices from Eisenhower to Bush, 80% of the time, just knowing the judge's ideology, you can guess how they'll vote in a case. So I calculated out the average and it comes out to 57%. So that is over half of the time. We don't have to know anything else about the case or about the judge. All we need to know is the judge is a Republican or Democrat, and we can guess how they will vote. This is not the same, though, as living constitutionalism and originalism or activism and restrainism. So there's a lot of people who think like activist judges must be liberal. In fact, there are conservative and liberal activist judges, and there are conservative and liberal restraintist judges. So these three ideas of judicial role, judicial interpretation, and judicial ideology often get conflated in popular discourse, but they are in fact different and manifest differently based on the specific judge. So for example, John Roberts is a conservative, but he is also a restraintist, and he actually hasn't spoken so much on whether he's an originalist or a living constitutionalist. On the other hand, Antonin Scalia is a conservative. He considers himself to be an originalist, but he's very much an activist judge who has no problem overturning the other branches. So you might expect that he would be restrainist because of the other two parts of his personality, but in fact, no, he's activist. So this is what I mean, like, we can't conflate these ideas because they are actually distinct and operate differently within each justice that is appointed. Okay, now I'm going to move on to how you get to the Supreme Court. So first, a controversy has to occur. You can't just walk up to the court and say, hey, I want you to take my case. You have to have a problem where you have actively been harmed for you to file a case. And you don't get to just go to the Supreme Court. You have to start in the lower court, although there are exceptions to this, and I'll talk about them later. But in general, you start in the lower court, and then you have to go to the middle level of courts, which is the appellate courts. And then the Supreme Court has to decide to take your case, which is called granting certiorari or granting cert. In order for the Supreme Court to grant cert, 4 justices have to decide they want to take the case. So it can't just be 1 or 2. It has to be at least 4 that say we want to take the case. And the Supreme Court gets over 10,000 petitions a year, and they only take between 80 to 120. So they take less than 1% of the cases that are presented to them. Most cases die at the appellate court level. But if they decide to grant certiorari and hear oral argument, they will schedule oral argument. You get 1 hour, 30 minutes for each side. And then after that, the judges will decide how the case should be decided. Why might the Supreme Court take a case? Well, there's several reasons when they are more likely to do so. First is when the US Solicitor General, excuse me, I'm sorry, I have something in my throat. Okay, hopefully that solved it. When the US Solicitor General is a party to the case, so when the US federal government is part of the case, then they are more likely to take it. If 2 states are fighting, then they're more likely to take it because the states can't go to their own state governments for them to resolve an issue. So for example, when New York and New Jersey were fighting over New York Harbor and where the lines would be drawn, they had to go to the Supreme Court for that. If a lot of amicus briefs have been filed, then they'll also take the case. An amicus brief is literally friend of the court, and anyone can file an amicus brief urging the court to take a case or urging the court to decide one way or another. And this is a signal to the court, if there are a lot of amicus briefs filed, that this case is very interesting and that there are a lot of people who have strong opinions on it. So it's a signal to them that they might want to take the case because there are so many people who are interested in the outcome. They also want to take a case if there's a disagreement in the lower courts. So our appellate court system covers different states. For example, North Carolina, South Carolina, and Virginia are in a circuit together. And Texas, Louisiana, and Oklahoma are in a circuit together. If the Texas, Oklahoma, Louisiana circuit says you can't have gay marriage, but the North Carolina, South Carolina, Virginia circuit says you can have gay marriage, then this is a problem for the Supreme Court because we have some states under one law and some states under a different law. When that happens, the Supreme Court wants to take the case so they can say, this is it for the country. And then lastly, the Supreme Court wants to take a case if they want to overturn the lower court. And that's just a purely strategic decision. At least 4 justices on the Supreme Court don't like what the lower court decided, so then they want to change it and they vote to take the case. The structure of the Supreme Court goes from October 1st to the beginning of May-ish, and that is organized into 4-week sessions. 2 weeks where they hear oral argument on different cases that they have decided to take, and then followed by 2 weeks of recess. And I'm going to talk more about what that is in a second. So there's 2 weeks of hearing oral argument, 2 weeks of conferencing and writing, 2 weeks of oral argument, 2 weeks of conferencing and writing. The decisions are released throughout the term, but most of them come in June and July, especially the most controversial ones. They hold on to those until the last minute, and so they can release the decision and then go on break. And then during August and September, they're technically on break, but they do meet periodically to vote on what to take for the next term. But they can do that remotely. So for example, Anthony Kennedy was always famous for going to Switzerland during this time and living in Switzerland while he voted remotely on what cases to take. Okay, so I said I was going to explain what recesses are. Recesses are after oral argument. So both sides have presented their case to the court. The court has to decide how they're going to write the decision. So in a conference, they discuss the case together, and it's just the 9 justices in a room. No one else is there. There are no cameras, no recording, just the 9 of them. And they vote on which side they think should win of the case. If the Chief Justice is in the majority, then he decides who writes the case or writes the opinion. And he could decide to write it himself, or he could assign it to someone else in the majority. If the Chief Justice is not in the majority, the most senior justice who is in the majority gets to decide who writes it. And again, they can decide to take it for themselves, or they can decide to who else is going to write it. So seniority wins here. And in fact, wins even down all the way to like who's going to get coffee. The least senior justice has to go get coffee for everyone else. So right now, Amy Coney Barrett is the one who has to go get coffee for everyone else. And Kavanaugh was lucky. He was only the least senior justice for a little bit. But there were several years where, for example, Breyer was the least senior justice, and he had to do it for like 6 years, where he was the one who had to get coffee for everyone else. So then once they've determined which side is going to win and who's going to write the opinion, then let's say, for example, John Roberts is going to write it. He tells his law clerks, write this opinion, and they usually write the first draft. So law clerks have significant influence over the ultimate text of an opinion. Then once the justice is happy with what their law clerks have written, they circulate that opinion to other judges or the other justices and receive feedback on that opinion. And they may accommodate judges. So for example, if Roberts has written an opinion, he sends it out. Kavanaugh might say, I'll join your opinion if you add a paragraph on this. And Thomas might say, I'll join your opinion if you add a paragraph on this. And, Sonia Sotomayor might say, I'm never joining this opinion because I hate it or whatever. But they do circulate the drafts amongst themselves because the judges who is writing the opinion wants his colleagues to join him, because you have to have at least 5 sign on to the opinion for it to have the force of law. This is where the vote is distinct from the opinion. The vote could be 7-2 for one side. But if at least 5 justices don't sign the opinion, then whatever they've decided does not become law. And the only thing that's decided is the person who got 7 votes wins. So judges are incentivized to write good opinions that their colleagues want to join, so that then that opinion has the force of law for lower courts. The average number of drafts that is circulated is 3. And it can go higher than that or lower than that. Usually there's more drafts whenever is later in the Supreme Court. There's more drafts when it's earlier in the term. The later they get in the term, the more slammed they are for time, and then there's fewer drafts. Okay, 2 more opinion types. What is a concurrence? A concurrence is when a justice agrees with the outcome of a decision, but not the majority reasoning. So I like the decision, the outcome that's being made, but I don't like why they're saying it should be made. So when are these more common? For conservatives, they are more common when they want to lay the groundwork for future cases. So they say, here's why I think this case should have been decided. I don't know that the majority is right. I think it should be decided like this for future cases that they anticipate coming up. For liberals, they want to write a concurrence when they want to limit the scope of the majority opinion for the lower courts. So this is where strategy is involved. You might be a liberal, especially on the court right now, when the court is 6 conservatives and 3 liberals. You might decide to vote with the majority so that you can limit the ruling for the future. And even if that doesn't exactly match what you'd like the outcome of the case to be, you can have more control over what the majority opinion says if you're on the winning side. So liberals like to use that strategy to try to limit the majority opinion and make it smaller rather than larger. And overall, concurrences have been on the ups since the Rehnquist court. The other type of opinion is a dissent, which is when a justice disagrees so strongly with the majority that they write an opposing opinion. And these are more common when there, as you might imagine, is significant ideological difference between the majority opinion and the dissenting justice. So when they feel so passionate that the majority is wrong, they feel like they have to write something pointing out all of the reasons they're wrong. Scalia loved to write dissents because he thought that his colleagues were often very silly, and he would write that in the dissent. I think they're silly. And they also write more dissents earlier in the term when the caseload is lighter. As I was just talking about, as the term gets closer to June, there are less dissents and concurrences because people simply don't have time to write them. The current justices on the Supreme Court are there, as I just said, there are 6 conservatives and 3 liberals. Stephen Breyer is retiring at the end of this term, and President Biden has nominated Ketanji Brown Jackson to replace him. And the Senate Judiciary Committee is going to vote on her confirmation next week, or it might be 2 weeks away. They were supposed to vote this week, but then they asked to move it back. And here is just a chart, actually, that my dear friend Rebecca Kreitzer made that shows the differences between the justices and who appointed them, the home state they're from, the law school they went to, and the religion of the justice. So you can see that a majority of them went to Harvard or Yale law schools. Many of them are from the coasts, so Maryland, Georgia, California, New York. Gorsuch is from Colorado and Barrett is from Louisiana, and that's odd. Normally they're from the coasts. And you can see that over time, the justices have been younger that have been nominated to the court. There's also been, if Ketanji Brown Jackson is confirmed, she would be the first Protestant on the Supreme Court in quite a while. How do Americans view the court? Well, in general, they are the most preferred branch of government. They get higher ratings than Congress or the president. But over time, they have been viewed less and less positively. So you can see in the chart on the left that in general, they hover in the 60s, but they are lower at 53 in 2021 than they have been in a little bit. From 2012 to 2014, you can see they were at 46 and 48% approval, which is pretty low for them. And you can also see the chart on the right is showing when the justices were nominated before their confirmation hearings, how did Americans feel about them? Over time, the bars are getting smaller and smaller, which means that less and less Americans are approving of that justice before the confirmation hearings. And this is a reflection of how Americans increasingly perceive that the Supreme Court is conservative and political. So the chart on the left again is showing that the favorability rating of the Supreme Court has decreased even within the last 3 years. And also that more and more Americans, the chart on the right is showing, that believe that the Supreme Court is conservative. And it is. It's 6 conservatives and 3 liberals. But you can see that even among Democrats, in August of 2020, only 47% thought they were conservative, and that jumped to 57% in January of 2022. And among all Americans, it jumped from 30% to 38%. So the amount of people who think that the court is the middle of the road has shrunk over time, which it leads us to, what are the politics of the Supreme Court? Are they political? The answer is yes. And as I was talking about, they have really been political since the founding of the United States. Hamilton wrote, actually, in Federalist number 78, that the Supreme Court should be the least dangerous branch to the political rights of the Constitution. So the Supreme Court shouldn't be political and they shouldn't be dangerous. But the first Supreme Court Chief Justice, John Jay, said, it is presumed that juries are the best judges of facts. It is, on the other hand, presumed that courts are the best judges of law. So even from the very beginning, the very first Chief Justice of the Supreme Court is acknowledging that the courts are going to be making political decisions about what the law says and not necessarily facts. And then Jefferson again said with dismay in 1819 that the Constitution, on this hypothesis of judicial review, is a mere thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. So even before the founding fathers have died, there's already a perception that the Supreme Court is political and not a neutral branch. You might ask if the court has taken Congress's power, and this is not what the founding fathers would have intended. And that answer is yes and no. The power of the Supreme Court today is likely greater than the founding fathers intended for it to be. But at the same time, Congress has given the Supreme Court that power by increasingly letting the other branches decide things for them. So for example, with the budget, Congress was supposed to write the budget for the federal government, but they decided in the early 1920s that they were going to give that power to the president, and he can write the budget. They'll vote on it, but he can write it. And that's them voluntarily giving the president power over the budget, because the person who gets to take the first draft is more likely to get what they want out of it. Now, this was done for practical reasons. Congress thought that the president would be more likely to know what he needs in form of funding, but it is giving power away to let the president take the first stab at the budget. Moving forward, with the Lilly Ledbetter Fair Pay Act and the Voting Rights Act of 1965, in both of these cases, Congress has failed to act, and the Supreme Court has stepped in and told them you should have. So for the Lilly Ledbetter Fair Pay Act, the whole reason that law exists is because Ruth Bader Ginsburg wrote in an opinion, hey, Congress, you should pass this thing. And then the Voting Rights Act of 1965 was defanged with Shelby County v. Holder in 2012 because the Congress failed to act. So then the Supreme Court stepped in and said, you haven't updated the formula for the Voting Rights Act in too long. The formula is old and reflects old views towards race. So we have to take this away from the states because you haven't updated it. So both of those laws, in one case, the Congress did fix it, and in the other case, they didn't. But all of those are evidence that Congress has given up power to the courts and to the executive branch voluntarily by refusing to act. So one of the reasons why we wanted to talk about the nomination and confirmation processes is because of how political they seem to have become. And the question is, are they more political now than they used to be? And the short answer to that is yes. But just so you know, for the process itself, a Supreme Court justice is nominated by the president, and the president asks for help from his advisors on who I should appoint. Liberal presidents tend to consult several progressive judicial groups. Conservative presidents consult the Federalist Society, which is the most prominent conservative judicial group. And they'll get a list of who they might appoint. And then they usually call in the top few candidates for interviews to see who they might like the best before they make the ultimate nomination. Senators of the president's party are also consulted because the Senate is who will end up confirming a justice. And whenever a president wants to nominate a justice from a certain state, so for example, Ketanji Brown Jackson is from Florida, then the president usually consults the 2 senators from that state, from Florida, as a courtesy to say like, hey, this justice is from your state. Do you support their nomination? And once the president has decided, they send the name to the Senate, and then the Senate holds confirmation hearings. The confirmation hearings are held in the Senate Judiciary Committee. Senators get to question the nominee and talk to them about their qualifications and their judicial philosophy. Usually justices try to dodge those questions because they don't want to say ahead of time, like, this is what I'm going to decide in certain cases. But it is popular for justices to say that they believe in originalism because it is perceived that that is the superior judicial interpretation. After the hearings, the committee votes on whether or not to confirm or to recommend confirmation to the full Senate. The full Senate then debates the confirmation and then they vote. So it is a several step process to get confirmed, but a simple majority of the Senate is what is required. This chart is showing you that over time, the confirmations have become more divided. So you can see across the top, the orange dots are showing who is confirmed. And a lot of the time they were confirmed with 100% votes. But more recently, you can see that, for example, President Trump's nominees are barely meeting the simple majority requirement. And usually, if the vote is that tight, the person is not confirmed, which are the blue dots across the bottom. So the confirmation hearings and confirmation process has become more political recently. And an example of this is for the current nominee, Ketanji Brown Jackson. These are public opinion polls from literally March 19th to 22nd, so very recently, who said that if you look at the bottom, the red circle shows that Republicans have said they should not confirm her and Democrats have said they should confirm her. So it's very much along partisan ideology. Who nominated her? If I like that person, I like her. If I don't like that person, I don't like her. The red arrow is interesting because what it's showing is the number of Americans who said they weren't sure. So if you look across, 33% of Americans said they weren't sure about Ketanji Brown Jackson. So while I'm saying to you that she is polarizing, like many of the most recent Supreme Court nominees, there is still a large information gap about judicial nominees in the first place. So you can take these perceptions of her kind of with a grain of salt, because at least a third of Americans are admitting they don't know. And the other ones probably likely also don't know. But we know from public opinion research that Americans like to offer an opinion, even if they aren't sure what their opinion should be, because they aren't comfortable saying, I don't know. Why has the confirmation process become so contentious? Well, one of the reasons is increased polarization. So the chart on the left is showing you that since 1994, the median Democrat in the United States has moved away from the median Republican in the United States. So the two that used to overlap a lot more in 1994 are further apart in 2014. And that's among average Americans. The chart on the right is showing you that in Congress as well, the two parties have moved further away from each other. And specifically, Republicans have become more conservative, moving away from Democrats. There is also an increased feeling of high stakes, where we have to nominate someone and put them on the court so they can be there a long time due to life-term appointment and influence the direction of the court for the foreseeable future. And so whenever you feel like you won't get that many chances to nominate someone and they're going to be on the court for a really long time, it makes the confirmation feel life and death. And when you feel that high stake, then you want to fight about it. If you nominated them, you're ready to go to the mat and defend that choice. If you didn't nominate them, you're ready to go to the mat to discredit them because you don't want to see a strong partisan of the other party put on the court. So I'm going to close by talking a little bit about current debates on the Supreme Court. And the three main ones that people are talking about right now are term limits, court packing, and the shadow docket. So first, term limits. What are term limits? Well, this is the idea that instead of having lifetime appointment, we would move to one single long term, like the Federal Reserve currently has. The Federal Reserve currently has 15-year staggered terms, and you can only serve once. So there have been several influential law articles that have argued that we should have term limits for the Supreme Court. One reason is we have increased life expectancy than they had in 1789. So if you nominate somebody to be on the court in 1789, you could reasonably expect them to serve for 5 to 10 years. But now justices are being nominated when they're 50, and they could reasonably be expected to serve for more like 30 years. So that's a much longer time than the founding fathers probably intended for a justice to sit on the Supreme Court. There are also increasing mental and physical health concerns as justices get older. One of the law articles that I could share the link to if you'd like, talks about how we know there are several justices who have stayed on the court long past their mental cognition has declined. And so their own family members have wanted them to retire from the court, and they've chosen not to. And this can only increase as justices stay on the court longer and longer. And this is part of why this idea that when judges are on the court for that long, it makes it feel more high stakes. So term limits could be a good way to reduce the politicization of the confirmation process by making it more regular when there's going to be new justices on the court. I can't see the bottom so I can't remember what I said right there. Let me move the little bar. Hold on. There we go. In 2020, there was a bill filed. Now I'm remembering what I said. There was a bill filed in the House to change the court to staggered 18-year terms. So you would serve one 18-year term and then leave. And the idea of a long term is to try to kind of take you out of the regular political process that takes place every 2 years. So you would be there a long time, but not too long of a time. Alexander Hamilton did write in Federalist number 78 that we needed lifetime appointment so that they could adhere to the Constitution. But an anti-federalist named Melancton Smith wrote in an anti-federalist paper that if you have people stay in position for a long time, they will become a fixed body, inattentive to the public good and selfish. So even again, among the founding fathers, we have different ideas about whether or not there should be term limits on the Supreme Court. In October of 2021, the National Judicial College asked judges what they thought. Should there be term limits? And 60% said yes, although they did disagree on how long that term should be. 40% said there should still be lifetime appointment. And Justice Breyer, who is retiring, said in his recent book that he strongly supports term limits. And he supports even a shorter time than he's actually been on the Supreme Court. The public believes that term limits are a good idea. And in fact, they also believe that justices to the Supreme Court should be elected. Both of these things would require a constitutional amendment, so they're unlikely to change. But Americans are in favor of the idea of shortening the lifetime appointment of Supreme Court justices. Court packing is another common debate about the Supreme Court right now, and that is the idea that we should add more justices to the Supreme Court than the 9 that we currently have. Historically, we haven't always had 9. We have had 9 since 1869, but before that, the size of the Supreme Court was changed 7 times. So it's not like there's no historical precedent for changing the size of the Supreme Court. FDR famously suggested that we should add a Supreme Court justice each time a justice on the court refused to retire after the age of 70. And this was widely reviled. You may have heard the phrase, a switch in time saves 9. That's what this is referring to. Eventually, some justices, to save the 9-person court, retired, and then another one changed his mind to vote with New Deal legislation so that they could stick with 9 judges on the court. But the point is that it has been suggested that there should be a different size. Some scholars argue that court packing has been effectively taboo since the 1950s, but others argue that when the Senate refused to hear confirmation hearings for Merrick Garland in 2016, and then they did hold hearings for Gorsuch right after that, that effectively constituted court packing or court changing of the size, because they refused to allow there to be 9 judges for nearly a year. And at the state court level, there have been efforts to increase the size, and it did happen in Georgia and Arizona, and similar proposals were considered in several other states. So court packing could potentially happen at the Supreme Court level, although again, it would require, well, no, I'm sorry, this one doesn't require a constitutional amendment. Tomorrow, Congress could decide to change the size of the court. Of course, they'd have to all agree, which is something Congress doesn't necessarily do these days. And if you ask Americans, they generally do not favor court packing. So if you look at all voters, 45% in October said that there should be only 9, and 46% in April of 2021. So roughly similar percentages said there should only be 9 justices. And the people who hold this view the strongest are Republicans, which is natural because they currently control the Supreme Court. If you ask Americans what's better, should we have term limits or add more justices, Americans overwhelmingly would rather have term limits. So even Democrats and independents prefer to have term limits over the idea of adding more justices to the court. The last controversial debate among the Supreme Court is the shadow docket. And I wanted to talk about this because it is currently a very controversial idea, and Rebecca mentioned it on Tuesday. And it's the idea of using emergency orders or summary decisions without oral argument, and usually the decision is issued without explanation. Has it been used before? Yes, it has, but usually for routine orders, like telling one party they can have more time to file a brief. Very rarely was it used for emergency injunctions, but there were a couple throughout history, like when the Supreme Court stopped the Nixon administration from bombing Cambodia during the Vietnam War. Another example is when the Supreme Court issued a brief stay of the execution of Julius and Ethel Rosenberg. But the fact that I can even just tell you, these are basically the times it was used, is it was very, very rare. Since 2017, though, there has been a marked increase in the number of shadow docket cases. And this is primarily due to the Trump administration. So the Trump administration filed 41 emergency petitions in their term. The Obama and George W. Bush administrations, by comparison, filed 8 between them. So for 16 years, we had 8. And then in 4, we had 41. That's a huge increase. And you can see that if the Supreme Court gets these emergency requests, they usually grant it if the federal government or religious petitioners are involved. If it's a private party, then they deny the emergency injunction. Why might the shadow docket not be a problem? Well, according to several justices, they have to have a shadow docket because of the increasing caseload of the Supreme Court. As I said earlier, there were over 10,000 petitions they receive each year. And the only way that they can issue a certain amount of decisions is if they issue some of them without explanation. So some justices say we have to have a shadow docket so that we can talk about more cases. And Samuel Alito likened it to complaining about an emergency room treating too many accident victims. So what he's saying there is, in an emergency, we have to act like it's an emergency. Why are people acting like it's a problem? On the other hand, many other people think that the shadow docket is a problem for several reasons. One of them is that the shadow docket decisions are unsigned, so we have no idea which justices felt about what on what side. There usually is not an explanation of the decision, which means that we, the people, can't understand why they made the decision that they made. And if they are going to be a part of our democratic government, then we should know why they're deciding what they're doing. Also, as the chart I just showed you showed, they're granted more often when the federal government is involved compared to private parties. So again, you can see here that when the federal government is involved, and the federal government made 11 petitions and they were granted 10 of them. Whereas private parties made 97 petitions and they were denied 95 of them, and then 2 were withdrawn. So what this is saying is there's a bias here where the Supreme Court is allowing the federal government and religious groups to operate on the shadow docket, but not others. And that doesn't look good for fairness reasons. And one professor of law at Harvard said, the idea of unexplained, unreasoned court orders seems so contrary to what courts are supposed to be about. If courts don't have to defend their decision, then they're just acts of will of power. They're not even pretending to be legal decisions. So the shadow docket is quite controversial. In closing, I just want to leave you with a quote from my personal favorite jurist, Richard Posner, who is the most cited legal scholar of the 20th century. And he said, there's tremendous amount of sheer hypocrisy in judicial opinion writing. Judges have a terrible anxiety about being thought to base their opinions on guesses and on their personal views. To allay that anxiety, they rely on the apparatus of precedent and history, and much of that is extremely phony. So even this eminent jurist is saying the Supreme Court and other judges are acting based on their own fears and attitudes. So you can't expect there to be a total, like I was saying earlier, you can't expect justices to be a robot. They won't be. And even if they try to put a veneer of originalism or precedent on it, it is still a political decision that they're making. And that is everything that I have. Sorry, I went a little bit over. But I wanted to make sure that I try to hit all of the highlights of the current issues in the Supreme Court.
Thank you so much. And there's definitely a lot going on with the Supreme Court right now. I mean, always, but particularly right now. And we do have a number of questions. One thing I wanted to ask about, and it may be, someone else may have asked it here, I'm not sure. Recusals. So there's a conflict of interest, or let's say a spouse is doing something and, of a justice. There's a lot of talk about this. So what can be done about it? Anything?
Essentially nothing. The judges are supposed to recuse themselves based on their own sense of whether there's a conflict of interest or not. There's not actually a code of ethics at the Supreme Court. So Chief Justice John Roberts could talk to Clarence Thomas and say, you should recuse yourself. But at the end of the day, it's Justice Thomas's decision. And if they decide not to recuse, there's nothing that can force them to.
Okay, so that means, okay, that seems contrary. Contrary to democratic principles. Okay, so let's go up and see what we have here. Okay, so I think I have started with my questions. I have been finding over the recent past during the nomination and hearing process that it's, as you pointed out, it's very political and it's very contentious and it's becoming very ugly. So I'm wondering, have they always been so public, televised and out there for everybody to see, or and if they have, is there anything that says that they can't be made private at this point? Let's say a transcript of the proceedings made available after the fact. Something to make it less dramatic and an opportunity for people to perform.
Well, so funnily enough, confirmation hearings were not regular practice until 1955. So for most of our history, there weren't even confirmation hearings where the person went before the Senate Judiciary Committee and talked to them. For most of our history, the president nominated someone and sent it to the committee. They talked amongst themselves and voted amongst themselves. And then they sent it on to the full Senate. It wasn't until we had our very first confirmation hearing in 1925. And that one was because there was some controversy over the nominee and the president didn't want to withdraw their nominee. And they thought it would be a good idea for them to go talk to the Senate Judiciary Committee and explain themselves. And once they did, they were confirmed. So it worked. But that's the first time we ever had a confirmation hearing. And then in 1955, they were made regular and they've been used since then. But there's no rules that say they have to have them. And there's no rules that say they have to be televised. This is entirely a choice that the Senate Judiciary Committee has made. Does that answer your question?
It does. So I guess we need to write to our senators and say, please take it off of TV.
Well, you bring up a good point, though, in that having it on TV and having so many Americans a part of the process is probably what's driving the perception that the court is getting more political, because those confirmation hearings become so polarized and contentious. When more Americans are watching them, it naturally would make them feel like the court must be as contentious and polarized as these hearings are.
Well, and particularly if it's happening, as you're approaching an election period. I mean, they get away from the purpose of the hearing and gravitate to using it for other reasons.
Mm-hmm.
Okay, so I put a question in there about limiting terms, but you covered that very well. Here's another question. How many justices have retired versus those who died while serving?
That's actually a really good question. I don't know the answer to that. I will say that my perception is that in the last 50 years or so, it's been more common for someone to die in office than retire. And part of that is because we're living longer and we have better medical care that keeps people on the court longer. But I don't actually know any hard numbers on that. That's a really interesting question.
Okay. Here's a comment. It seems like the shadow docket was used by the Trump administration to basically get the decision they want from SCOTUS. If the volume of cases is a problem, maybe they can expand the court. Let's see.
I just want to say one thing really quickly. The comment about the Trump administration using the shadow docket is exactly correct. As I showed in the presentation, the use of the shadow docket was much, much rarer prior to the Trump administration. And the reason why they filed so many is because a lot of their decisions were getting stays, or they were getting put injunctions by lower courts. And then the Trump administration would appeal to the Supreme Court and say, no, don't have an injunction yet. Let us prove our point, and then we will move forward. And so it was the Trump administration that was asking the court to do this more often. The court doesn't have to accept, but they chose to. And now they have started this practice where they're taking these cases more and more. And since the Biden administration has begun, they're still taking shadow docket cases, but instead of approving the administration decisions, they're disapproving of the administration decisions, which is just leading to further perception that the court is super political and tilted towards one party.
Right. Let's see. Here's a recusal question. You may have answered it. What ethics and recusal issues have happened with Supreme Court judges, does SCOTUS need to be held to the same standards as lower court judges?
So there have been several times in the past when Supreme Court judges have recused themselves from cases. So for example, Clarence Thomas recused himself from the famous Virginia VMI case because that Ruth Bader Ginsburg wrote the opinion on and said that there should be women admitted to VMI. He recused himself because his son was a cadet at VMI at the time. And historically, there have been lots of cases where judges recuse themselves because of a perceived conflict of interest. But again, like I was saying, there's no rule that says they have to. Like, this is when you definitely recuse yourself and this is when you don't have to. It's all entirely up to the personal decision of the Supreme Court justice. And if we wanted to hold them to the same standard as lower court judges, we would have to establish some sort of code of ethics for Supreme Court justices. But that would involve Congress getting involved and telling them, you know, this is what you have to do. And Congress isn't passing a whole lot of legislation these days because they're so polarized. So it would be really, really difficult to impose rules about recusal and ethics onto the Supreme Court.
That did come up. I saw that come up in the news today, that Nancy Pelosi's talking about that. Don't know where it'll go, but yeah. Okay, so here's one of my questions. With regards to the shadow docket, as a citizen, can we request a justification for a decision? For instance, we can ask for freedom through freedom of information. We can request information. Can we request something from the court, an explanation or a justification?
No, we can't. Sorry, we don't get to do that. Freedom of information requests work when a document already exists and you ask, as a member of our democracy, I want to see this government document. But it has to exist for you to ask for it. And the shadow docket, there is no written up explanation.
Okay, all right. Let's see.
Oh, thank you, Rebecca, for fixing my answer about retiring versus dying. So my perception was off. I thought they were dying more recently, but it looks like Rebecca found that they're retiring and resigning more recently. I do know that Sandra Day O'Connor retired to take care of her husband because he was sick with Alzheimer's. Right. But I also know that she really regretted doing that.
Okay. All right. Well, I think that is all the questions. If anybody else has any that they wanted to ask. All right. Well, thank you very much. This was, I learned a lot tonight about the Supreme Court. So this, for me personally, was very helpful. Again, this evening was also recorded, and so we will be making both tonight's and Tuesday night's videos available on our website, lwvodc.org, in the next week or so. So thank you very much, and I hope everyone has a good evening.
Thank you so much for having me, and for everyone who came. I always love to talk about the Supreme Court.
Thanks. Thank you.